Good afternoon. I'd like to call to order the meeting of the Santa Barbara City Council Ordinance Committee of January 11th. Ms. Peterson, would you please call the roll?
Chair Bendy White.
Here.
Member House.
Here.
Member Hotchkiss.
Here.
And would you kindly read the item before us today?
The item before you today is the medical marijuana dispensary ordinance. Dispensaries permitted under the city's March 2008 dispensary ordinance.
Thank you. Mr. Wiley, are you making the presentation
today?
Yes, I am. Great.
Thank you, Mr. Chair. I thought I would give you some background information, although I'll go through it pretty quickly because I am fairly sure you know most of this background. But you may recall that in, let's see, was late 2007, early 2008, I think it would be true to say the city was seeing storefront medical marijuana dispensaries, really, to our knowledge, for the first time, cropping up. They, by and large, obtained business license. They paid their business license tax through the city, and they felt that they were under the state attorney general guidelines that had been issued in 2008, that they could open as any other business in the city. In other words, at being a business, they would have to be in a non-residential zone, but they were opening in the city. And as a result, in 2008, the city underwent a fairly extensive public process to develop an ordinance. So this was late 2007, early 2008. And the city's first amendment to the zoning code was adopted in March of 2008, regulating dispensaries, storefront medical marijuana dispensaries. And I won't go into detail about the state law, but of course this started with the Compassionate Use Act of 1996, which was a state statute approved by the voters in 1996. And at least in my perception, there was some real years there when the meaning of that statute was unclear, in particular as in terms of larger groups of people providing medical marijuana to qualified patients. And that's essentially, I think, starting in about 2006, 2007, I think, say in the city of Oakland and the city of San Francisco, we started seeing storefront dispensaries. And then, as I say, the Attorney General guidelines indicated that under some very limited circumstances, storefront medical marijuana dispensaries could be consistent with state law, with the Compassionate Use Act. I should also add that in 2003, effective in 2004, the state legislature adopted the Medical Marijuana Program Act. And again, there is language in the Medical Marijuana Program Act about collective and cooperative groups of people providing medical marijuana to qualified patients. And so we saw this growth of dispensaries. And the city's ordinance of March 2008 regulated those, made it clear, for example, that they could not occur in a residential zone. And it started to have what would be fairly typical for, say, an adult business zoning ordinance, radius requirements, to not have a dispensary, for example, within so many feet of a school or within so many feet of a park and other sensitive uses like that. The 2008 ordinance, however, did not limit the number of dispensaries within the city. And there were some other issues with it that in retrospect developed. For example, the whole process, the permitting process, was not appealable to the city council. And I think there was a fair amount of public view, or a fair number of members of the public who thought that these things should be appealable to the city council. As a result, in 2009, the city council decided to revise that ordinance, and I know most of you were here and you recall going through that process, so I won't spend a whole lot of time. But we had a lot of public hearings at the ordinance committee level, planning commission hearings, and we ended up in June of 2010, last June, at the council. Well, let me back up. In the spring, of 2010, pretty much at the council level, there was the fairly typical legislative process of trying to reach a consensus, and in this case, because it's an amendment to the zoning ordinance, to reach a consensus acceptable to 5 members of the council. Long story short, in June of 2010, the council decided to adopt an ordinance, storefront dispensary ordinance, that limited the number of dispensaries in the city to 3, that took the 3 dispensaries which had been permitted under the March 2008 ordinance and applied the new ordinance to them, and in fact 2 out of those 3 permitted dispensaries were told that their locations were no longer acceptable, 500 North Milpas and 631 Olive Street. The ordinance of the June 2010 ordinance also, for the first time, went to more of what we called a block face approach, and in fact that evolved into specific block faces where dispensaries could be permitted, and incidentally that was pretty much why the 500 North Milpas location, at least as I perceived it, was not acceptable at the time. But it evolved into areas of the city where a dispensary might be permitted, and in which case there could not be another dispensary in that same area of the city, say Milpa Street or say Outer State Street. So it was block faces, areas of the city where they might be permitted and not more than 1 dispensary per area, and then also not more than 1, locational requirements in terms of other dispensaries being close to each other. And coupled with the final decision to have not more than 3 dispensaries, with only 1 out of the prior dispensaries which had been permitted being in an acceptable location. That resulted in litigation against the city, 2 lawsuits filed by the dispensaries that had been permitted under the March of 2008 ordinance. And as you know, in November, we received a ruling from a federal district court judge with respect to a preliminary injunction, which is a pretrial injunction. It is binding until the trial, and it is not a final determination. But in our case, it will be binding until the trial date, which right now happens to be a year from now. And possibly more significantly for our purposes today, the standard for issuing a preliminary injunction, one of the tests is, does the judge see that the plaintiff or the party asking for the injunction is likely to prevail? And in this case, the judge does feel that the dispensary, in this case 500 North Milpas, is likely to prevail. Now, what are they going to prevail on? They apparently will prevail on their claim that they had a vested right under the March 2008 ordinance to the permit that they received. Their theory, and it's pretty clear that the judge is inclined at this point to agree with that theory, is that they spend a great deal of money in obtaining that permit from the city, but more importantly then in doing the tenant improvements that are necessary, that the city required in order to open up pursuant to that permit. And there are court cases that make it very clear that something like this can establish a fundamental vested right, and the basis for a city basically taking away that right have to be pretty strong. And when it happens, the amortization period, the period under which you allow them some time frame to become legal, has to be fairly reasonable. In our case, the federal judge found it very significant that we had only allowed a total of 3 dispensaries, including the ones that had been permitted, and he felt that that was a pretty clear sign that it would be virtually impossible for these dispensaries that are losing their grandfather status, if you will, to obtain a new permit. That was a factor, major factor in his ruling, again on a preliminary basis, that they're likely to prevail in their claim of a vested right. Which prompted me as the city attorney to come to you and here today and to advise you that it might be a good idea at least from my perspective, from a legal perspective, from a liability perspective on behalf of the city, to think about grandfathering in the 2 dispensaries that were permitted under the March of 2008 ordinance. Now, having said that, we've also had 6 months of experience since June of 2010, and it occurs to me that that experience, it does inform, should inform this process. In other words, for example, as this status report will point out, we've only had 2 new permits applied for under the June 2010 ordinance. At this point, only 1 of those permits has been granted. That is for the for a dispensary on 16, I think it's 16 North La Cumbre, South La Cumbre. So in terms of, and I recall the process, there seemed to be a fairly strong consensus for the geographic distribution of these dispensaries within the city, to not have one area of the city be the dispensary district, but to have, if state law is going to allow these things, and it does, and that's, I have just as an aside, that's the overall context of this, is that these things are allowed by state law according to the Attorney General under some limited circumstances. So to have that geographic distribution, to have within the last 6 months to look at the experience, for example, of these former, the dispensaries that were permitted under the former ordinance, and to see how have they performed, has there been problems with those. So anyway, that's my background to this status report, because in my experience, the first question in these discussions, it's always been, where are we today? How many dispensaries do we actually have out there? What's going on? And so another point I have to make, though, is the illegal dispensaries. The ones that crop up in the middle of the night, the ones that are, whether you call them a fly-by-night operation, don't even make a pretense of trying to get a city permit or, advising the city that they feel they have some legal right to operate. And we, at any one time, we've got a few of those dispensaries. And it is, by and large, a police matter, which is not to say that if the police department gives us evidence of an illegal operation, the city attorney's office won't take action. We will immediately go to Superior Court and try to close down these illegal dispensaries that open up, from one day to the next. And we do get members of the public telling us there's a dispensary here, a dispensary there, and we do follow up on that. We're checking them out. That's not what I'm talking about here on this list of 8 dispensaries. 331 North Milpas is a dispensary that was permitted under the March of 2008 ordinance. It was a location that the most recent ordinance said was still a legal block face for a dispensary. So while they had to tell us they were going to begin conforming with the day-to-day operational requirements of the new ordinance, they did not need to get a new permit for that location. However, and it's a big however, there, in the meantime, I don't recall exactly when this happened, their operator was arrested and charged with felony drug charges, and apparently having to do with this dispensary. When and if those charges are resolved with a conviction, we will, as the city police department, city attorney's office, need to take action to look at whether we revoke that permit if the operator of that dispensary is convicted. Until then, we can't and shouldn't do anything about it because it's just an arrest. But if there is a conviction, we will do something about that one.
Mr. Wiley, is a felony conviction, that's the basis on which you make that decision? And is that automatic, that you cannot operate a dispensary if you've got a felony conviction?
That certainly is clear in the ordinance that yes, that you can't be issued a permit And we would consider that grounds for revocation of this permit. Yeah. 3128 State Street, Santa Barbara Patients Group. This is the operators who have applied to move to 16 South La Cumbre. And that permit was issued, I believe it was December 16th by or granted at least by the staff hearing officer, December 16th. The appeal period on that has now run and no one appealed. It's my understanding that there was no opposition even at the staff hearing officer hearing. So that, we consider that a permit finally issued by the city. And I do believe the representatives of that operator are here today and would like to speak. 631 Olive, again, that's a dispensary that was permitted under the March of 2008 ordinance. One of the questions then, and they did file a federal court lawsuit very similar to the 500 North Milpas lawsuit. One of the questions then is, I think they've been operating for some time now. I don't know exactly how. Have there been problems with their operation? I know in the permit review process there were some concerns from the Housing Authority, and I think it was the Girls Club. And for that reason, the Planning Commission told them, we want you to have regular meetings with the Housing Authority and the Girls Club to work out any issues. It's my understanding in checking with the police department and others that we have not had any complaints about that dispensary or its operation, or even, for example, police calls. And I want to be clear, though, as we'll get into in the next one, just because a dispensary has had some police calls doesn't necessarily mean that there's been a problem with that operation, because sometimes they're the ones that call the police. And that's what we want them to do. So we can't, hold that against them. And 500 North Milpas, this is basically the operators who filed the litigation, and they would be allowed to remain if this ordinance is enacted. Again, the question, have there been problems with this operation? And to our knowledge, there haven't been. And we've asked around, the people who should know. There have been a few police calls, but apparently they all have to do with false alarms on their alarm system for their building. So they may need to deal with that under the city's false alarm ordinance, but I don't know that that's something we would fault their operation for in this case. Then on the backside, and let me turn this over. We have had apparently off and on over the last few years a dispensary at 2915 De La Vina, and we have been forced to file a Superior Court enforcement action against this dispensary because we have some pretty solid evidence that they discontinued their operation. And dispensaries that discontinued their operation for a period of time or moved were not treated as non-conforming legal uses that could remain open while they applied for a new permit. And so we are pursuing that Superior Court enforcement action to close this dispensary down. Now, this happens to be a location, Upper De La Vina, that is a block face that could be permitted. And this operator applied for a permit under the new ordinance, and at the same December 16th staff hearing officer hearing, the staff hearing officer denied that permit. I don't know. Yes, it was appealed to the Planning Commission. So that's a bit of a question mark. We may have a dispensary on Upper De La Vina at this location, depending on what the Planning Commission does with that, and conceivably depending on whether an appeal goes to the City Council or not.
Mr. Wiley, excuse me, do you know the grounds of that denial?
Yes, I believe one of the grounds, and we were real upfront with this operator about this, is that we told the operator we have evidence that they had discontinued operating at this location, and that as a result, if they don't comply with the city's ordinance, the city attorney's office would recommend denial of a new permit. And our thinking there is that unless someone can show us why they're not complying with the law, they shouldn't be granted a new permit, that the fundamental basis of that permit is their ability to comply with the law in the future. Secondarily, I saw a police report where the operator of this dispensary, in our view, negligently stored 50 pounds of marijuana, and that 50 pounds of marijuana was stolen out of a public storage area. That's a concern. You know, we don't want an operator that doesn't have the good sense of how to store medical marijuana properly so that it doesn't get easily stolen. And the police report indicated this was pretty easily stolen out of a public storage locker. 27 Parker Way, they're a dispensary that had been around for years, so there's sort of, under the prior ordinance, they were allowed to continue so long as they got a new permit under the new ordinance. But this location could not be permitted, and they're under Superior Court judgment that they would close down by the end of this month, and we have every intention in insisting that they comply with that judgment and that they close down. And at this point, I don't believe we have any indication that they're not going to, that they will. Then there was a dispensary at 3516 State Street, and they have closed. Again, I believe those operators were charged. The criminal drug charges are pending against those operators, and they've closed down. And at one point, and this has been closed for some time, there was a dispensary at 100 East Haley, and that's also closed. That's my summary of where we are with dispensaries, and I know from prior experience in terms of the number, ultimately in the long run, that I understood most of the council members could foresee being appropriate within this city. I think we're within those numbers, and that forms a large part of the basis of my recommendation to look at this new ordinance and also to resolve this litigation if we can and if the council thinks it's appropriate. And I want to be clear about that because the enactment of a city ordinance is a very public process, and despite the city attorney making a recommendation, ultimately this is your decision, and if the public and the council consider this, and the council says, well, we got elected to be responsive and we don't feel what the city attorney is recommending is appropriate, then that's what it is. That's what's appropriate, and we'll address the litigation in other ways if need be. Which brings me to the draft ordinance that you have in your package that was in the public package. I also have copies of that. It's fairly straightforward. It would, despite some legal boilerplate in there, it's uncodified so it doesn't actually get codified into the hardbound municipal code. It doesn't need to be, because this particular provision establishing this 6-month amortization period under the June of 2010 ordinance was uncodified. So to undo that, we can do that in an uncodified way. This ordinance would tell the dispensaries that were permitted under the March of 2008 ordinance, 500 North Milpas and 631 Olive, that they are grandfathered in, and so long as they comply with the other provisions of that March 2008 ordinance, the operational provisions, and so long as they don't close down, because this principle of a non-conforming use closing down and losing their non-conforming status is long-standing, and so long as they don't close operation and so long as they comply with the operational requirements, they would be grandfathered in indefinitely. One final point, and just to mention this, of course, we had the ballot measure in November, and I see that however you take the public input that we should receive from that decision by the voters as factoring into this. Ultimately, I could see the city ending up with a limited number of dispensaries, 5 or less, probably less, and geographically distributed. Again, nothing will allow these people, these operators, to operate these things in any way but in full compliance with the state law, with the Medical Marijuana Practices Act and the Compassionate Use Act. So, happy to answer any
Thank
questions.
you, Mr. Wiley. I have a couple of questions on this. One is, we have proposed to have two grandfathered in dispensaries. Going forward, those dispensaries can continue to exist until some things happen. Can they be transferred from a buyer, from a seller to a buyer, for example? Is that something that would that trigger the end of the grandfathering?
Well, it would trigger the city moving to revoke their permit, because even both ordinances, March 2008 and the most recent, the new ordinance, did not allow transfers. And it has to be the same operators.
It has to be the same person. It's not like Chevron, where this thing can just go on indefinitely. If this same person or persons must be running this operation in order for it to stay in business. So that's a definite
Conceivably, if someone wanted to transfer a dispensary to different individuals, what they would need to do is those new individuals would have to come in. You could do this in sort of what I'd call an escrow scenario. And it happens with, say, a dance permit, which can't be transferred. You have the new operators get a new permit for that same location. That could happen.
Okay, great. Thank you. Mr. House, do you have any questions?
Yeah, I'm going to just tiptoe into this a little bit and just ask a couple questions, because what you have up on the screen there is kind of important, I think. Mr. Wiley, I guess the purpose then for which we're here is to address the two, in a responsible way from the city's perspective, the two sources of litigation with just simply making some small language changes that address those concerns that we think would satisfy a court in the future and address what we heard from the judge. Is that basically what?
That's correct. And when we say we mean you. I mean it's your call. But yes, that's correct.
That's your advice and our decision.
Right. Exactly.
Right. I like how you put it right back on us here. And then just one of the things, when I read this piece of paper that you gave us, because it was up here, I don't know if this is 100% true, but I had the transcript of the hearing for the 2915 De La Vina Compassion Center. I just went back what I was doing while you're talking, reviewing what was the basis or the grounds upon which they didn't receive their permit. And at one point, they had, I think, called in that theft, but that theft was part of the conversation. But I was noting here that as part of their appeal to the Planning Commission, the transcript's been submitted, and it says from the staff, it said, but primarily we don't have a problem with how the facility's been run. There's been no complaints about it. It seems to be a professionally run organization. Haven't received any complaints. Not about the running of the dispensary. It's more about compliance with the old ordinance, which had to do with that 30-day business. And then just right after that, and I just want to make sure to answer Mr. Hotchkiss's request for what was the grounds upon which they lost that. It says, and we can't, because of that, we can't make the finding in number 12, which had to do with the condition of the 30-day requirement. And it said further about the theft, it says, I think, with regards to number 9, which had to do with that robbery, which they since, I think, have corrected. Working with the police department, we can get over 9. It's the 12 part, the 30-day part, with the non-conforming. That the city's determination is non-conforming. So it seemed to be that it really did come down pretty substantially on the basis of this 30-day requirement to stay in operation. Now, I'm only basing that on the transcripts here. There might have been something else, but it seemed to be what was being said. Am I off on that?
If that's what the staff hearing officer said, that's what she said. When I hear that, I'm concerned there may have been a little bit of a misunderstanding in the sense that a new permit really is prospective. It's like you take someone and you take their application and their operational plan that required, and what we know about them, and is this someone who should be allowed one of these permits because they are discretionarily issued permits. And if I were advising the staff hearing officer, it's like, we did, in fact, advise the staff hearing officer. The city attorney's office feels that someone who has been advised that there is evidence they're not complying with the law, wants them to comply, and it will be forced to file a Superior Court and code enforcement action unless they comply, and they say, well, we're not complying. That's a relevant factor that the staff hearing officer should take into consideration. Their response may be, well, you're wrong about us having closed down. Well, that's fine. Maybe they can prove that, but that's remains to be seen, and that'll be an issue in the Superior Court enforcement action possibly. Secondarily, just to be clear, we're not calling anything a robbery. Robbery is the taking of someone, the person of someone, by force or fear. No one was robbed of any marijuana.
Right. I'm sorry. I meant the theft or whatever.
Yeah, it was probably a burglary, you know, and it was the theft, but no one was robbed. And the only point there was that was a pretty dumb way to store 50 pounds of medical marijuana, frankly, and we're not particularly interested in a permittee using bad judgment in storing medical marijuana.
Yeah, I didn't mean to get us all diverted on that, although I just wanted to make sure that that part was accurate, that the findings were that the 30-day piece had not been met. And in any case, I'm looking for ways today, Mr. Chair, if we had the opportunity to resolve what might even be potential litigation against the city in very subtle changes to the language that we have in front of us today, I would like us to entertain that, and I'll talk about that more in a minute.
Thank you, Mr. House. Mr. Hotchkiss?
Yeah, I just want to clarify, again, when you were talking, answering Mr. White's question, if person A is running a dispensary legally and wants to sell it or is approached by person B, they can do so long as person B is cleared by the staff and investigation center?
No, I'm glad you asked, because I realized as I was saying it would be like getting a new permit, and it would be the full 9 yards for that new person to get a new permit, and there wouldn't be any sort of presumption or entitlement to that new permit. But what it would be was, let's say we're down to 3 permitted locations, and somebody says, you know, I'm going to get out of this business. I'd like to transfer it to even, let's say, my son, who would be a good operator.
Right.
The ordinance would allow a new permit for the old operation closing and then a new one closing at that same, and it could be from one day to the next.
Opening.
Yeah, but there would be absolute discretion on whether to grant that new permit. Just because you have an existing permit doesn't entitle you to transfer it. Or
okay, if it was a non-conforming one and that happened, then it would be shut down, correct?
That's correct.
And we would eventually, the hope is, or the thought is, come back to the 3 that originally were prescribed by City Council.
Right.
Okay, thank you.
Yeah.
Thank you, Mr. Wiley. Now, I saw at least one slip for public participation. There are 3. Great. So I'd like to open the public portion of this meeting. We have 3 speakers. I'd ask that you limit your comments to 2 minutes. First being Derek Weston, followed by Patrick Forney.
Good afternoon. Happy New Year. I'm Derek Weston here on behalf of the Santa Barbara Patients Group regarding the application of the current ordinance to their situation. Now, as you know, they are currently located at 3128 State Street and have been for many, many, many years, almost 10. We're delighted that they just have received staff hearing officer approval for relocation to 16 South La Cumbre, and that is final. And Mr. Wiley is correct. There was no opposition at all of any kind to the proposal. So the issue that I'm raising today, and which is covered in a letter that I sent to staff today, is not an action item, just an item for your information. We first filed the application for 16 South La Cumbre in November of 2009, so well over a year ago. The processing of that application was suspended during the entire time that the ordinance was being considered, and then it was further suspended during the time that the referendum was before the voters, so that staff for about a year did not process the application at all and only began right after the referendum vote. We promptly got a hearing on December, I think it was 15th, but it might have been 16th, and it was approved. The reason I'm telling you this is that the current ordinance requires that the patients group cease operations at the end of this month, and that means that they would be out of business until they're actually able to open at the new location. We think that that would just be unfair. We've been working with the city in good faith throughout this whole period. We couldn't have done it faster because we filed it over a year ago and have just been waiting. So we've discussed this with Mr. Wiley, and our proposal is that I should tell you that we think it'll take about 6 to 10 weeks for the physical construction. As soon as a certificate of occupancy is issued in the building, as soon as a building permit is issued, we don't know how long it will take to get a building permit. Hopefully very, very fast, because we actually filed the application a year ago and amended it. So
your time is up, but I want to ask you further. You're asking how would maybe we just ask our city attorney on this. For example, I'm impressed that staff, considering that this thing was set aside for so long, that you got to hearing that fast, if they actually truly did sit on it without acting on it all that time. What could be done reasonably to, it makes sense to me anyway, and perhaps others would consider it. What would we do, what could the city do to allow a little extra time at the old location?
Mr. Chair, I think because it would pretty much take city attorney action to enforce the ordinance, if we had a consensus, an understanding that under these circumstances, there perhaps would be letters exchanged saying that under the circumstances, and I tend to agree when I didn't think about it until Mr. Weston pointed this out, with the ballot measure, and particularly the staff saying, well, we can't process applications while that's pending, and even in fact, it wouldn't make any sense under any circumstances for an applicant to sign a lease or to start making tenant improvements, not knowing what was going to happen at the election, that in retrospect, it seems pretty fair to agree on a letter basis that so long as, it's a limited period of time, 60 to 90 days, and so long as one dispensary closes before the next one opens, that could be doable.
Okay, great. Yeah. Thank you.
So, as I say, it's not an action item. We just want to be totally upfront that
hopefully
this and I think Captain Martell has no objection at all.
Thank you. All right, Patrick Forney to be followed by Gilbert Gainer.
Members of the Ordinance Committee, we're here today because the Ordinance Committee is being asked by the City Attorney's Office to recommend to the Council adoption of changes to the medical marijuana ordinance in order to settle a lawsuit against the City. This is a perfect time to address our situation as well, because this subject matter is yet again before you. The Compassion Center is the oldest dispensary in Santa Barbara, operating since 2000. We are the only dispensary in California to have registered nurses on its staff. We have strong support from our neighbors, and we have strong support from the medical community, including the Director of Clinical Practice at Cottage Hospital, Dr. Stephen Ozea, who has called us an indispensable resource and, quote, a model dispensary in the letter that we have on file. We run a dispensary professionally, and it's a comfortable place to be for older patients who suffer from a variety of ailments, including cancer and chemotherapy associated with it, as well as AIDS, Crohn's disease, MS, and others. We have been denied a permit by the staff hearing officer, and our appeal to the Planning Commission will not be heard until after January 26th, February 3rd to be exact. And the deadline for closure of dispensaries as instructed by the current ordinance. We are requesting either a change in this ordinance's language for accommodation of due process and or an adoption for the consent calendar for an extension of the January 26th deadline. Our staff hearing officer meeting was delayed because of everything that was on hold because of the Planning Department until after the November election, as we've been hearing previously, with regards to Measure T. If Measure T had passed, then updating our application would have been moot. So myself and other applicants were told to wait because the dispensaries in the city would have been banned, at which point it would have been unnecessary to continue the process. Because the ballot measure was defeated in November in a landslide, we continued with the process, but as you can see, it is delayed at no fault of our own. If you don't make the necessary changes, unfortunately, we have to go to court in order to remain open until after January 6th, and we're left with no choice. I just wanted to also address briefly the situation of a burglary or a theft.
You're out. I tell you, you're out of time. But I want to ask you. I'll ask kind of the same question that I asked of Mr. Weston, and that is, so you would be looking for an extension, a time extension of.
Well, and whatever
30 to 60 days.
Whatever the period is in order to complete the appeal process, it would just be at the termination of the appeal process is when we look for that extension.
Extension to the appeal.
Just so that we have a fair due process because of the anomaly of this Measure T thing impeding the process.
And I would ask that you provide a written explanation about the burglary. You're out of time, but obviously you will be cycling through here for a while. So if you would do that, that would be helpful.
Okay, because it's important that you understand the context.
Exactly. So help us with that.
Okay, thanks for your time, Mr. White.
Thank you. All right, and our final speaker is Gilbert Gaynor.
Yes, thank you, Mr. Chair, Mr. Hotchkiss, Mr. House. I am the attorney for Mr. Formey and the Compassion Center. Based on the colloquy between the chair and my client just a moment ago, I think that much of what I would say, assuming the city attorney and the other members of the council are agreeable, will be somewhat redundant, but let me say it anyway, because I think it provides helpful background for this problem. As Mr. Formey explained, we're here today because we want to avert legal action against the city. My client timely applied for a permit. It was denied on grounds that we frankly think have zero legal merit. You should have received in your inboxes in email a copy of our letter of appeal, which is 22 pages and which talks about the numerous legal deficiencies of the city attorney's position and the numerous other deficiencies of the medical marijuana ordinance taken as a whole. The appeal won't be heard until at least February 3rd, so we do need some time. Unless immediate action is taken, we will be forced to go to court. We will do so promptly. Santa Barbara has arguably the single most restrictive medical marijuana dispensary ordinance in the state of California. As explained in my letter of appeal, we believe the constitutionality of numerous sections of the ordinance is highly suspect. And we further believe that when we challenge the constitutionality of these sections, they'll be struck down by a court on injunctive relief. And when we do that, if we're forced to do it, if we can't get an extension of time to see this appeal through, and an appeal that sees reason in our view, then we will go forward. And what the city will have at the end of this process, I predict, is a medical marijuana ordinance that will be much less restrictive than the one that's currently on the books, and it will have incurred the expenses and the legal, which would include attorney fees, and the legal uncertainty of further litigation. I'm here to avert that today, and I sincerely hope on behalf of my client and on behalf of the city that can be achieved this afternoon.
Thank you very much.
Thank you very much. Any questions, gentlemen?
Any questions? No. Thank you very much.
Your listen.
All right. Are there any other people here who want to speak? All right, then I will close the public portion of this hearing, and it's back to the committee. Mr. Hotchkiss?
Mr. Wiley, how could De La Vina be permitted under the existing ordinance? It cannot. Is that correct?
It would have to get that permit from the Planning Commission, and they've filed an appeal to do that. And then if it isn't issued by the Planning Commission, they would have a right to appeal that to the City Council. So we're kind of in the middle of the process. So
But it's beyond our restricted 3.
Well, I guess the alternative would be to revise the ordinance to deal with De La Vina, and I am not recommending that.
All right, so I'm still confused here. They're saying, give us time to continue something that we've already said is a no-no. Correct?
Right, and in fact, the City Attorney's Office has a Superior Court lawsuit filed. So while they may challenge that, it seems to me the appropriate place for that challenge is in Superior Court, where they can raise any defenses they might want to raise to our lawsuit trying to close them down.
Okay, thank you.
Any other questions? Mr. House, any other questions?
let's just talk about what we have in front of us first. The changes, I want to be sure I understand them. And oh, good, you put it up there. As I read this, where in the first paragraph under Section 1 it says, those dispensaries which are being operated in a manner consistent with state law and which were permitted by the city under City Ordinance number 5449, as adopted by Council on March 25th, may, despite a nonconforming location, remain as legal nonconforming use at such permitted locations, provided that, and then there's the two caveats. So, Mr. Wiley, is effectively this addresses two existing dispensaries? Okay, and they're concerned. So then these two particular requirements, consistent on a day-to-day operational basis, and then the same 30-day, looking forward, I guess, the same 30-day period of not being, of staying in business and not being out of business for 30 days. Okay, got it. So this is a way to deal in a very kind of laser-like fashion with these two dispensaries.
Yes, that's correct. Because we only had 3 permitted dispensaries under the March 2008 ordinance, one of those 3, that location was is still okay. They didn't need to get a new permit. We were just down to the 2 that we had the grandfathering issue, and we tried to grandfather them in at 6 months, and the judge says that's just not reasonable.
Okay. It could be though that with our restriction of 3, that doing this, we ultimately could have as many as, say, 5, I would guess. I mean, because you've got the 3 that, depending on what happens on De La Vina or whatever, but you could end up having the 3 that we said were limited, and then these 2 are kind of added on top because of the court's response to the whole thing.
That's correct, and that's a good point. If this ordinance were to be adopted, it would be 2 plus 3. That could be allowed.
Okay, and then if these were to
Right
go out
now,
of business, then it might by attrition come back down to 3, but that would be in the future.
And right now we only have 1 location that's been permitted under the new ordinance. Yeah.
Right, exactly.
Keeping in mind also that with only 1 per area, it also then,
right.
Yeah.
Okay. So, Mr. Chair, it helps me understand that, and then I'll just ask this next question. I know you took a pretty strong stand there a minute ago against doing anything that might affect or have anything to do with the De La Vina location, and I just want to at least introduce the concept here and just get your feedback on it a little bit, because, and Mr. Chair, one of the things that I've been following this for a long time, and that particular location has quite a clientele, and they've been in business for a long time. And they have 2 things in particular, one of which I don't know if that was really the finding for their denial, but it was in the conversation about this issue of security off-site, and it appears to me they may have resolved that. But this other one about the 30-day deal still needs to be settled one way or another, and the appeal is their first relief, right, to go to the Planning Commission and make their case. So that's first. I want to just address the concern that was raised and ask you about this gap between the extension on the 26th and the appeal. In other words, they haven't completed the process yet, which they're due. But because they're in that process, which began after, because everybody was put on hold, but they began that process, now they would literally have to close their doors during the process in which they're appealing. So it appears that they would be penalized while they're trying to make their, something fundamental rule of the law or something seems like a fundamental principle. Maybe you can give us some way to get around that.
Councilmember House, if you assume what they say is true, you make a good point. We have not assumed what they have said is true. Our information has been for some time now that they shut down and tried to move to a new location, and that they have not operated consistently on De La Vina Street. We have that information from several sources. It's up to a judge ultimately to decide whether we've got convincing proof, but we felt we had enough to conclude that they lost their nonconforming status. That's different than the one at the 3100 block of State Street, who have, they opened before there was any permitting requirement. They have operated, as far as we know, in everything the city has asked them to do, they've operated in accordance with, including getting a new permit for a new location because we said the 3100 block could no longer be allowed. That's different from an operation where we said to them, we have information, evidence that you shut down, you lost your legal status. You know, we really are big believers in complying with the law, and so you should shut down while you're applying for a new permit, and if you get that new permit, then you're fine. You can reopen. Mm-hmm. They refuse to shut down. We feel that is a little bit different.
Okay. Well, I guess I'm not going to perseverate, but I just want to get this one piece. It seems like we've made an assertion that an enterprise that's been in business for 10 years or more, and that they lapse somehow for 30 days, but that hasn't been, that process of our asserting that hasn't been completed yet and found to be accurate. They're in the middle of their process of actually proving their side of it. So during that process, from a fundamental law perspective, or principle of law, I guess maybe we'll bear the liability if ultimately we're found out that they were in business, and then they could sue us for the lost revenue and all the rest. But I got to tell you, I'm not advising you to worry about liability in this case. If you want to make a decision with respect to this Delavina location on its merits, I encourage you to do that. Either way, I'm not taking. But if you're going to ask me, should we worry about a lawsuit here? My answer is I wouldn't. Yeah, I've never known you to shirk from anything like that. Last thing is this 30-day business. Of what value is that to us to have this here? It used to be important because we had a whole bunch of them that just popped up out of nowhere, and they were coming and going and all that. And what benefit is of it to the city of Santa Barbara to have this number 2 here?
Well, 2 questions, I think. The 30 days as opposed to some other number of days is your call. It's very, I think under some circumstances, generally our non-conforming use ordinance uses the term 30 days, and that's probably why we have it here with respect to dispensaries. It could be 60, it could be 90, it could be 180. So that's that. You could take it out altogether, but then that would, I think, cause some real problems in terms of somebody could shut down for months, and it really would slide into different operators. It would be kind of go hand in hand with a transfer that we didn't know about.
Okay, got it. So if it were 60 or 120 or not even that much, 60 or 90, it would still fulfill the same function.
Yes.
Thank you.
Mr. Hotchkiss?
I make a motion that we pass the ordinance as submitted.
I'll second that, but I want to also make my comments to that motion, and that is, I think that first of all, we have heard from our council that we have a significant risk and a significant problem with the 2 non-conforming dispensaries that have taken us to court already. And that there is a way for that number to go down over time through attrition. This is as high of a bar of requirement on a business that I've heard that this can't even be transferred from one person to another, so that we can see the spirit of the city's 3 dispensary ordinance come onto the ground over time. So I'm satisfied with that. Again, per our attorney's advice and discussion about the Delavina facility, we will see with the litigation that's now in place whether this facility has in fact kept its doors open and kept active as a business over time, and that the applicant has the right to move forward with those in both those processes. Is obligated to, or I guess has to either adhere to the city requirements or prevail in court on the court issue, and then pursue the permit process as it's doing now. So for those reasons, I can support the ordinance.
Mr. Mayor, Mr. Chair, just to be clear about something, in this case with respect to Delavina, should the Planning Commission or the City Council grant them a permit, all of this argument about whether they close down
30 days, et cetera.
is water under the bridge, and it's like, well, you got a permit, so that's all that really matters now. So
Okay.
just to keep that in mind. Yeah.
Thank you. Did you have a comment, Mr. Hess?
First, one more thing, Mr. Wiley. So, you still left me wondering. So on January 26th, I'm just going to see if I can find this out. January 26th, even when they're in an appeal process, that business is going to have to close down during the appeal to the Planning Commission and then possibly the City Council, or would it be a similar situation to what you said to Mr. Weston a minute ago, that given that they've been an ongoing concern and here they are in the middle of this process, that at least until they've extended their remedies, that they would be able to continue in operation?
Councilmember House, unlike Mr. Weston's client, who, to our knowledge, has operated in full compliance, has never closed down, has never received a notice of violation from the city attorney's office saying, we understand you closed down, you need to shut that operation down, and has never forced the city attorney's office to file a code enforcement action to make that happen. De La Vina has done that. So actually the date, I believe, is January 29th. It's 6 months from June 29th or thereabouts.
Okay.
So as far as we know, I'm expecting De La Vina is not going to close down. We ordered them to close down before. We had to file a lawsuit, and they still haven't closed down. And we're being forced to go to court to get a court order to close them down. So I don't think January 29th is going to change their point of view at all.
Okay. And the only reason I took the trouble to say that out loud was literally there's two changes I've written into here that could be made today that would literally resolve pretty much everything having to do with 2915 De La Vina as well as these other two. It would be very small changes. It would be just adding the words or legal nonconforming to the first section and removing or changing the 30-day to 60 or 90 days in the second. And that would get us literally out of court and completely calm the waters with regards to one facility that I think most of us had anticipated would be one of the three. And so I don't have any objections with the current language, so I'll support that ordinance, or that motion. But I'm going to just give a stab at that right after we're done.
All right, so the call for the question. All those in favor say aye.
Aye.
Opposed?
And Mr. Chair, just in consideration of what I was just saying, one of the things that I've noticed is that the basis upon which we're in this snare with this other facility, which it would be an opportunity today for us to resolve that very easily within what we have in front of us, would be to just include the little bit more open language in Section 1. Instead of just having that laser-like focus on those two, have it say legal non-conforming after the parenthesis here in Section 1. And then in the second one, to just simply either let go of number 2 or to indicate a 60-day period. And those two things would resolve three things at once today. It wouldn't be it's not like we have a bad actor here. We have somebody with a great track record. And I'm just wondering if I put that, I will do that. I'll move that we do that and just see if there's anyone here who would support it with a second and we could consider it. All right, well, thank you very much.
I'm not going to second that, and I'm not going to support it. I feel like we have the process where our attorney has taken action on this, and I want to see how that comes out, as well as we can have the appeal process go forward at the legislative level.
Thank you for your consideration.
Thank you. All right, well, there being no other business before us, then I'll adjourn the Ordinance Committee.